Welcome to everyone who is joining us. Thank you so much. We'll just be a minute as we let a few more people in from the waiting room. Welcome to everyone joining. We're just going to give it 30 seconds or so more and we'll get started. Okay, I think we'll get started. So firstly, hello, thank you so much for joining. I think we'll see a few more people trickle in as we get started. I just wanted to introduce myself. My name is Lucy Allen and I am the Managing Director of Barbary Global. And today we are absolutely delighted to be joined by LPC Law, who are going to take us through a very exciting and unique workshop. We will be looking at advocacy and really getting some key insights and giving you the opportunity and chance to ask lots of questions as well. So today we're joined by Estelle Hamilton, Holly Corder and Pete Blackmore from LPC. And without further ado, I am going to pass you over to Holly to get started. Thank you, Holly.
Thank you, Lucy. Good afternoon and thank you all for attending today. My name is Holly Corder and I'm a Senior Advocacy Manager at LPC Law. As Lucy has mentioned, I'm joined here today by Estelle Hamilton, who is a member of our recruitment team, and Pete Blackmore, a partner of the firm. Today, our purpose is to talk to you about the county court advocacy opportunities that we have available across England and Wales. I'm briefly going to cover who we are, what we do, and the bespoke advocacy service that we offer to our clients. We will also be conducting a live advocacy workshop showcasing a mock mortgage possession hearing to give you an insight into the types of hearing that you may attend. I hope you find today useful, and if you do have any questions, there will be an opportunity to ask these at the end. So who are LPC Law? LPC Law is a firm of solicitors. Our primary focus is on civil litigation, and we specialise in providing a high-quality advocacy service to clients throughout England and Wales. We act for a broad range of clients, including financial institutions, companies, and individuals, some of whom you can see on this slide here. For example, we represent many of the high street lenders, including HSBC and Lloyds Bank, and companies such as BMW and Apple. We act either through the client directly or through their solicitors. The advocates at LPC Law represent these clients in court. They put forward submissions to the judge and they liaise with the client or their solicitors both before and after each hearing. So a bit more about who we are and what we do. So on the board here, you can see the map of England and Wales and how this is split into different circuits according to where our advocates are located. We are the market leaders in advocacy. In 2019, we attended over 60,000 hearings. And since we started in 1994, we have attended over 1.5 million hearings. We offer a nationwide service to all of our clients, and we can cover all of the county courts in England and Wales. We are able to do this because we have approximately 200 advocates working with us on a self-employed basis, attending the county courts near to where they live. The advocacy service we provide has two limbs. One, we attend hearings in open court, and this work is carried out by qualified solicitors or barristers. And two, we also attend hearings in judges' chambers, and this work is carried out by bar and LPC graduates. You can do this work if you are supervised by a solicitor and the matter takes place in judges' chambers. Depending on what stage you're at in your career will determine what types of hearings you can attend. In terms of the type of work that we do, LPC Law attend all types of civil hearings covering practice areas including housing, personal injury, insolvency, and consumer credit. Typical hearings you may be involved in are interim applications, mortgage possessions, bankruptcy, return of goods, and so forth. As you progress and your experience grows, you can also attend more complex hearings such as small claims trials. LPC Law do not undertake family or criminal work. In addition, in 2020, LPC Law established 25 Canada Square chambers. This was in response to client demand for a more experienced, specialised service to handle non-standard matters. We currently have 16 barristers and solicitor advocates, 2 pupils due to finish pupillage this summer, and we have 3 pupils joining us over the next 12 months. Many of our solicitor advocates joined LPC Law to gain advocacy experience. They then progressed their careers by obtaining their higher rights and are now accepting more complex and lucrative work from at 25 Canada Square. Quite simply, working for LPC Law can open a number of doors for you. Now that we've introduced LPC Law and what we do, rather than simply telling you what it is about, we thought you'd give a flavour of what it is like to be a county court advocate. We are therefore now going to show you an example of a mortgage possession hearing to give you an insight into the type of hearing that you may attend. I will be playing the role of the solicitor's agent for the claimant, which is the role that you will be doing at court. Pete Blackmore will be presiding as our district judge, and Estelle Hamilton will be playing the defendant. After the hearing, we will dig deeper into some of the issues raised and what we expect of advocates instructed by us. Introduce Pete and Estelle.
Should we turn off screen sharing? Hello everyone, can you see us?
Yes, we can. Yeah.
Excellent. Okay. All right, we shall go straight into the hearing then. This is claim number K9GW6658. I understand it's the matter of Bank of Wales and Boston, an emergency application that's been put in front of me. And I understand I have Ms. Corder for the claimant respondent, and Ms. Boston, you're the defendant applicant.
Yes, Judge.
Good morning. So I understand that we're here today to consider your application, Ms. Boston, to suspend a warrant of possession on a mortgage property. I understand that the bailiffs have attended your house this morning.
Correct, Judge.
Ms. Boston, I appreciate that whilst it's your application, and no doubt you will have a lot to say, I think first I'm going to ask Ms. Corder to provide me with some background to this particular account and the litigation, if that's all right.
Okay, Judge.
Ms. Boston, could you, sorry, Ms. Corder, could you please provide me with the relevant figures on this mortgage account?
Yes, Judge, thank you. The outstanding balance is £15,450
Yes.
and 72 pence.
Yes.
The arrears are £9,247
Yes.
and 37 pence.
Yes.
The current monthly instalment is £840 and 67 pence.
Yes.
The last payment was for £840 and 67 pence on the 30th of June 2022.
Yes.
And the remaining term is 5 months.
Okay. Well, I see usually every Friday about sort of 30 mortgage cases come before me, and it's very rare to have as little as that outstanding on the account. It doesn't seem at all a lot in these days. Could you provide me a little bit of detail about the background? So when a possession order was made, that sort of thing?
Thank you, Judge. Well, this relates to a mortgage that was entered into on the 30th of November 1998
Yes.
for 25 years.
Okay.
The defendant fell into arrears in July 2022, and a possession order was made by District Judge Blythe Crenshaw on the 25th of November 2022. There is a warrant for possession that was due to be executed today at 10:30, and the defendant lodged an application to suspend the warrant late yesterday afternoon. There have been persistent arrears on this account since July 2022.
Miss Boston, you've heard what Miss Corder has said about the background to this matter and the relevant figures. I don't expect you to know them to the penny, but does that all sound correct to you, or do you disagree with any of that?
No, I believe that's correct, Judge.
Okay, thank you. Miss Corden, I assume you'll want to hand up to me the mortgage deed and the office copy entries from the land registry in order to prove your client's entitlement to possession.
Well, Judge, I can pass you these documents to you if you so require. However, I'm not sure that you will need these during today's hearing, as this is an application hearing and the possession order has already been granted by District Judge Blythe Crenshaw.
Apologies, sorry, I was running in automatic mode. I do so many of the possession hearings that I'm used to checking the paperwork first thing. You're right, your client has already demonstrated their entitlement to possession. What's your client's position in respect of this application? Are you consenting or do you oppose?
No, sir. I'm instructed to seek that the application by Miss Boston is dismissed today.
Okay. Right, then just as a sort of a starting point, I want to make sure that I've got all the relevant documents in front of me. Miss Boston, I can see that you've put in an application on the form N244, which is the standard court application form. And in it, you simply say that you want the court to stop the repossession of your property. Have you prepared any witness statements or any any other documents that you want me to look at?
No, Judge, I wasn't aware that I had to do one of those.
No, that's absolutely fine. It's just that I wanted to make sure that I've got everything in front of me that I need. And likewise, Miss Corder, your client's not prepared a witness statement in response, I assume.
No, Judge, due to the short time frame of receiving the application, no witness statement has been prepared.
Okay, well, in that case, I'll have to obviously listen to you both very carefully and make my mind up purely on that. Now, Miss Boston, as judge, I do have the power to make several orders subject to certain criteria being met. One of those orders I could potentially make is, as you asked, to suspend the warrant, which usually means that I pause any further execution of it, i.e. stop the bailiffs taking possession, but it would normally be subject to conditions such as you making payments. If you follow those criteria, if you follow those conditions, that usually stops the bailiffs taking possession. And if you were to break those conditions, then they might apply for the bailiffs to set another appointment. With that in mind, what do you want to tell me today about your application and why you want to stop the bailiffs taking possession?
Well, Judge, the reason why I'm making this application is because I now do have a new job, and of course I don't want to lose my home. I paid my mortgage for over 20 years, which is a very long time. I lost my job because I hurt my back, unfortunately, so I wasn't able to work on it or earn any money to pay the mortgage. I did get depressed. I buried my head in the sand, admittedly, and I didn't attend the last hearing that I was supposed to. And now I'm in a situation where the bank wants to take my home off me. I can now make these payments because I have this new job, and I did inform the lawyer before the hearing today.
By the lawyer, do you mean Miss Corder, or have you got your own representative?
No, Miss Corder.
Okay, thank you. Is that right, Miss Corder? Were you informed of that proposal?
That is correct, sir. The defendant has offered to pay the current monthly instalment and £100 a month towards the arrears.
Okay. Well, isn't that acceptable to your client? I mean, it seems to me that it's more than reasonable, and what Miss Boston has said about paying her mortgage for 20 years seems to be correct. I mean, she's got a well-established history of paying her mortgage up until comparatively recently.
Well, Judge, I have taken instructions on the offer, but my instructions are that the offer is to be rejected. There is no proof of the defendant's income and expenditure information today to show that the mortgage is affordable. Further, the defendant's new job has only been evidenced with a job offer letter, which details a 6-month probation period. So there is a doubt as to whether the defendant would be able to keep up and maintain those payments in the future. There is also the fact that there are only 5 months remaining on the mortgage term. So the payments offered of £100 per month would not clear the outstanding balance in the remaining term.
Well, then I argue I shouldn't be allowed at least some time to find the necessary proof today. They never told me that I'd need to bring this in the hearing. An offer is an offer from my employer. And why would I know to bring this proof in advance to you?
Yes. Well, I'm not too worried about the probationary period at this stage, because I understand a job could be lost at any point and any job's going to be subject to a probation period. But I am more concerned about the absence of any income and expenditure information, because frankly, Miss Boston, I need to understand how the figures add up. In the circumstances, I would be inclined to consider an adjournment, Ms. Corder, to allow Miss Boston to provide information. Why don't I order an adjournment, and we could come back and discuss this in a few weeks?
Well, Judge, I would respectfully request that you do not order an adjournment today. As you're aware, the court's discretion in respect of mortgage possession matters lies in section 36 of the Administration of Justice Act 1970. As I'm sure you're aware, the court can suspend possession if the defendant proves that they are likely to be able to pay any sums due within a reasonable period. Any sums due are the current monthly instalment and an amount towards the arrears, and the reasonable period is the remaining term. The case of State Bank of New South Wales trading as Colonial State Bank and Carey Harrison III states that there is no discretion beyond section 36 to delay the claimant's possession of the property in law, and the claimant has already obtained their possession order. It would therefore be prejudicial to the claimant today to prevent them from being able to recover the property, and it would not be in line with the overriding objective to adjourn the hearing as proposed.
Yes.
Apologies, Judge, but even if you think that it is likely that the payments will be made, which the claimant does doubt on the evidence provided or lack of, I would submit that this is insufficient to meet the requirements under section 36, and that is your only power to suspend or adjourn today.
Yes. Sorry, Ms. Corder, could I check my understanding? You say that the remaining term is the period of the mortgage remaining. We have here 5 months left on this mortgage, unless it's extended, and an arrears of over 9,000. So does that mean, in effect, with the monthly payment, with the monthly instalment, the defendant Ms. Boston will need to make payments of nearly £2,000 per month to pay that 9,200 off?
That is correct, sir. In line with the case of Abbey National and Cheltenham and Gloucester and Norgan, the starting point for the court to consider is the remaining term of the mortgage. So that does require a Norgan minimum of the arrears being divided over the remaining term, which is in this case the 5 months.
So in effect, the minimum amount Miss Boston is going to have to pay in order for me to have any discretion here is over £2,500 a month, I think.
That is correct, Judge, yes.
Miss Boston, I'm afraid that Miss Corder has raised a very valid point here, and it's not a good use of the court's time, nor is it sort of fair to keep this matter in the ongoing for longer than is necessary or reasonable. I'm worried here that the payments that you'll have to make are very high, and I don't have any evidence of affordability.
Well, then I say at least give me a week or two to sell the boat I have. It's worth over £50,000, so I'll be able to cover the arrears quite easily. I don't understand why you're not helping me. I said I can pay the amount to you. It's not my fault I got hurt at work and then wasn't able to get my life back together and pay the mortgage. I should at least be given the chance to prove that to the court today.
Miss Boston, I can understand this must be extremely difficult for you, but please try and remain calm. We're going to listen to you as carefully, listen to you very carefully, and I want to make an order that accommodates you if possible. But ultimately, there are certain restrictions on the law. I should ask you to repeat something. Did you say this was a boat?
Yes, it's my barge in the lock. It's floating but permanently moored.
Miss Corder, I've never dealt with a possession hearing regarding a boat before, permanently moored or not. I'm not sure I can order possession of a boat. I thought this concerned land. Don't I have to refer this matter to the Admiralty Court if it's to do with a vessel and ownership of that?
Well, Judge, I have to admit I'm not sure of the procedure here, but I don't see any reason why you should not be able to make an order in this case today, because it is still in relation to a mortgage. I don't believe it should make a difference that the property that is the subject of the mortgage is a boat or a building. It still remains a dwelling and there is a title number. Further, the original possession order, which was granted back on the 25th of November, that was granted in this court by District Judge Blythe Crenshaw. So there should be no difference for this application today to suspend that possession order. The original possession order, it has not been set aside, nor has it been appealed since it was made. So I would therefore argue that the possession order stands. I would respectfully submit that ultimately the only question before you today, Judge, is whether to grant or dismiss the application, not whether you have the jurisdiction to do so.
Thank you, Ms. Corder. You are right. I mean, I do have my own questions of sort of academic interest, but fundamentally the point is here is that my colleague has made a possession order and I should not assume that, or I do not have even the power to look behind that. If my colleague must have been satisfied that was the appropriate order to make. And I'm not a court of appeal. Okay. Ms. Boston, I'm afraid that as this is your application, the burden of proof is upon you to demonstrate that you can satisfy me that your circumstances have changed in such a way that I'm able to exercise my discretion, which means that here that you're able to make the payments that are required. As I've already alluded to, those payments would be extremely high to pay off the arrears over the remaining term of the mortgage. And I don't have really, other than you've demonstrated that you've got a new job, I don't have any evidence of your income in order to make an assessment of that. So my decision today is that, unfortunately, I do have to dismiss your application. I do note as a side note that the time for the execution of the warrant has actually passed. And I've been informed that by the usher that the bailiffs have moved on already as they have other appointments in their day. Accordingly, as a matter of perhaps more luck than anything else for you, the bailiffs are not going to repossess the property today, I understand. I'm going to direct that they refix the appointment on the first available date. You've therefore been granted a little bit of a reprieve by the hand of God, as it were. And I suggest that what you do is you consider your position, and if you do want to put in another application, you make sure that there's supporting evidence so that I can properly consider, or the next judge can properly consider your income on the next occasion. Okay. With that in mind, I'd like to thank you both and say good morning.
Thank you, Judge.
Well, this isn't fair. I said I could make the payments. What does this mean for me now then?
Miss Boston, I'm afraid I'm not in a position to give you any form of advice, and neither for that matter is Miss Corder. But I would recommend that next time you're here, you try and seek advice from the duty advisor. There is a duty advisor available at the court for possession matters. In the meantime, I'm afraid I'm going to have to ask you both to leave, as I have a very urgent family injunction matter to hear. But I would ask Miss Corder perhaps if you and Miss Boston could speak, and you could provide her with any with an explanation for any parts of this legal process that are still not understood.
Thank you, Judge. I will do so.
Okay. Thank you. Good day.
So thank you to Pete and Estelle for joining me there in the hearing. It does conclude the Northcote Mortgage possession hearing. I'm just going to reshare the slides. I won't be one moment. Thank you. So that was, like I said, a mock mortgage possession hearing, which is roughly a typical hearing that you would attend on a day-to-day basis. The hearing itself, it may or may not be what you were expecting. Each hearing is, of course, different, but generally they follow the same format. Typically, we attend hearings that are in chambers as opposed to those that are in open court. Often, as you could see, there is tremendous time pressure because these types of hearings are typically listed for between 10 and 15 minutes only. Some courts even, such as Chelmsford, for example, they even list their possession hearings for just 5 minutes. Consequently, the judge expects to receive short and succinct submissions. Most judges will expect an advocate to give snappy responses and will rarely give longer than a minute or two for each submission. These hearings, again, as was shown in the demonstration, are also judge-led. The judge will determine what information that they need in order to be able to reach their decision, and they often do so without allowing much time for back and forth or rebuttals. However, again, as was demonstrated, they are not infallible and they do sometimes get things wrong, and it is the advocate to point this out. And sometimes the questions that they ask may throw you. So let's first look into the judicial intervention that took place during the hearing. As a starting point, it is important to note that in these cases you can expect judicial intervention, sometimes quite a lot of judicial intervention, and hearing management by the judge. For the most part, the judge will ask you questions that you should know the answer to. For example, when the judge asks, is this acceptable in relation to the defendant's offer? I offered no because I had clear instructions that the offer had been rejected. When the judge mentioned that they would be inclined to order an adjournment today, I opposed this because the law around it, such as the case of State Bank of New South Wales and Carey Harrison III, supports that. This is part of the law that we would expect our advocates to be able to recite readily. But before you panic, we do provide a comprehensive guide that has been created by advocacy managers across many years, which contains all of the information that we think you should need. We also have a team of advocacy managers who are on hand at all points of time. So you do have any questions, you can contact them either on the law or more practical, if, for example, you're running late to court. So there is plenty of support available. However, there is the occasional question that comes from left field entirely, and you may or may not have any clue on how to respond. Such as, for example, in this hearing when the judge raised and asked about transfer up to the Maritime Court. In a hearing, I would not know the answer to that question off the top of my head, and I think it would be the case for many, if not all, of our advocates. The important thing to do, though, in that situation is to try and make an logical argument while still protecting your client's interests. Transferring to the Maritime Court in this example would result in a significant delay to the claimant, and there is a good chance that it would then be transferred back to the County Court, which would then take even further time. Furthermore, it doesn't follow logically that simply because this mortgage relates to a houseboat, that it would be anything beyond a standard mortgage hearing and out of the court's jurisdiction. It is perfectly fine not to have the answer to everything you are asked. The one thing, though, however, that we do expect is for our advocates to be able to think on their feet and to think of a potential solution rather than simply holding your hands up and not fighting to protect your client's interests. The client's interest should always be at the forefront, and you should always seek an order that supports that. So, having mentioned what we expect about advocates being able to think on their feet, what else do we also expect of our advocates? Well, I guess the main key concern is that of preparation. It's a big frustration, not only for LPC, but for our clients as well, when hearings are delayed, adjourned, or even worse, struck out because an advocate was improperly prepared. This could be something like not knowing the relevant law, such as the case that I mentioned in the hearing and previously. But it can also usually be something far more basic, like not having printed out a paper for the case that the judge then needs, and that he then adjourns the hearing as a result. We also expect and need good timekeeping. These cases usually only have 5 to 15-minute listing times, so the courts are incredibly strict about getting people in on time. There is also a lot to do when you're at court, both in and around the hearing. For example, you'll need to call your clients for figures and updated instructions. You'll need to find the defendant, and you will need to hold a conference with them or duty solicitor. In this example, the defendant had put forward an offer to the claimant's solicitor's agent, and she had taken further instructions before attending the hearing. You may also have multiple hearings on one day. So being able to balance this around arriving in good time and being in and out of different hearings is a skill that you must be able to have and able to succeed as an advocate. That now brings our workshop to its conclusion. So I'd like to thank you for your time for today and for witnessing our live mock-up possession hearing. And we'd like to open up the floor to any questions if you have any at all.
Hi Holly, it's Lucy. We do have one question in the chat. Hopefully there'll be a few more that start to come in as well. Do LPC Law recruit SQE students with experience of advocacy?
In order to be able to submit an application, my understanding is that you will have had to pass your SQE1 and SQE2. The reason for that, I understand that SQE2 covers the advocacy element, which is what we will need for when you join as an advocate. I hope that.
Thank you. There's no more questions in the chat. Not sure if anyone wants to take themselves off mute and ask in the group, or put something in the chat if not.
Oh, I do have further information in relation to the previous question. You can actually apply to become an advocate once you've completed your SQE1 exam. You can enter the assessment process. You would need to attend our offices for an assessment centre. If successful at our assessment centre, you will then enter our service commencement process. You can go through all of those stages, but prior to actually being able to commence work for LPC, you will have had to have completed your SQE2, but you can apply and get started on the process, so that hopefully when you do then take and complete and pass the SQE2, you can get started working as an advocate immediately after your results are received.
Thanks, Holly. And we've got another question that's along similar lines. What of those qualified from a different jurisdiction if they're exempt from SQE2? I'm assuming it's the same initial process that you just outlined around application.
I would I tend to be this one.
Yeah, I mean, what we would do, I think, is we look at people who are qualified in other jurisdictions on a kind of a case-by-case basis. What we have to do is sort of satisfy ourselves of advocacy experience and working in a similar jurisdiction. So we would look at, you know, what your experience was, what the other jurisdiction where you were qualified in, and then we'd make an assessment about whether we thought there was enough overlap and similarities there for us to have kind of confidence in your ability. But obviously, if you've been sort of studying the SQE, that would give us, you know, a good basis for thinking, well, they must have some sort of grounding and understanding of the civil procedure rules and so forth. So.
Super, thank you. We have another question. Do more example videos of mock hearings exist?
Loads. Yeah, we've got a few, haven't we?
Are
That
they
we
on YouTube?
they are well, they normally form part of our internal training. So when you join us, advocates do before coming, once passing an assessment, before coming into our sort of training centre for a day, there's about sort of 12 to 15 hours worth of online study, which includes lots and lots of studying kind of hearings, we've done in online videos, and also as well includes sort of very specific training and seminars on certain types of hearing. So as part of that, I think we've got quite a number of mock hearing videos. So it might be something that if people are interested in that sort of thing, it might be something that we can find those videos and share some of those to your students if they want to see what, say, a landlord and tenant hearing looks like, or what, say, a return of goods hearing looks like, something like that.
I would also say on our website, which we have got the website address up there, there are a number of videos which some of our advocates have recorded, where they talk about life as an advocate and their day-to-day experiences being an advocate at court. So that might also interest you if you want to go onto our website and have a look through those videos.
That's great. And I think that perhaps answers the next question, which is where can I find out more information about LPC law? Well, Holly, you've got quite a few quite a few links there.
I would say that our website is probably the best first point of call. There's a lot of information there, as you can see, lpc-law.co.uk/AR. We have, like I said, a number of videos, a lot of information on the application process, which I can talk you through next if that would assist, if that's what people would like to hear about. We also have our LinkedIn pages, Instagram, and we are on Twitter as well. So yeah, but I'd say the first place is have a look at the website. That's got most of the information.
That's great. And perhaps you could talk us through the application process. I think that would be helpful for people.
Okay, I will do so. In order to apply, like I said, visit the website. There's a lot of information on there. You will be required to submit a short online application form and provide a personal statement. I would say that the personal statement needs to cover why you want to be an advocate and why you want to be an advocate with LPC law. So please visit our website, see what we're about, what types of work we do, and please include that within your personal statement, why you want to work with us. Once we have received your application, then if successful, you will be invited to an assessment centre. They take place in our offices in Greenwich, London. You would be sent essentially a mock bundle 7 days in advance of the assessment centre date, and you will be required to prepare the case and submit a skeleton argument the day before your assessment centre by 12 p.m. and that is a strict deadline, so please please comply, because something is submitted after that deadline, we will have to withdraw your application. But the assessment centre itself, you will come into our offices. We will have a mock hearing similar to the one that has just taken place. The district judge will be played by one of our advocacy managers, and they will carry out the assessment. If you are successful through the assessment centre, as I noted earlier, you'll join our service commencement programme. There's a number of stages with that. First of all, as Pete has already discussed, we will send you a number of online seminars. Once you have watched them, there'll be a number of questions for you to answer, and then you are given the model answers. So that's a good starting point to do your preparation and your research into the types of law that we do. The seminars have lots of information, such as discussing the Section 36 Administration of Justice Act test and the case law surrounding it, etc. We will also arrange for you to shadow one of our current advocates in court, which I know most advocates enjoy because they get to actually experience the day-to-day life as an advocate. We will then have what we call pre-commencement chat. It's between an advocate and an advocacy manager. So you have an opportunity to ask any questions that you have at that point in a one-to-one conversation. And then finally, you'll be invited to come to a service commencement meeting, which again will take place in our offices in Greenwich. This starts around about 11:30 and finishes at 5 o'clock, and we run a number of different workshops introducing you to LPC, the Advocate Network, how that works, things like invoicing, conferencing, and you also get to meet everyone here in the office. So once those 4 steps have been completed, you will then be given your first briefs. You will have an opportunity to speak to an advocacy manager again before your first hearings. So any questions or any concerns that you have, you'll be able to talk through and discuss any submissions that you may or may not need to make. And then you will be good to go to court for your first hearing. So, and like I said, we have a team of advocacy managers on hand at all times to answer any problems that you may have.
That's great, really helpful. Thank you, Holly. We've got a question directly for you, Pete, from a Sohail Ismail. I'll give the name because it might ring a bell, but do LPC still offer advocacy training sessions at firms? I believe you did this at my old firm a few years ago, and I'm curious if this is still something LPC are open to.
Yes. Hi, Sahel. Yeah, we do sometimes go to firms and provide training, not normally on the advocacy side of things, because to be frank, we want to do the advocacy for you, but we will provide training on hearing types, what happens in hearings, and also sort of case preparation, that sort of thing, and kind of just educate people about what happens in hearings and things like that and how best to prepare. So certainly our larger clients, that's certainly something we offer, and we're always, as part of our kind of wider services, we want to give clients training and more information about what we do. And I suppose that's relevant as well for maybe people thinking about joining LPC Law, because I think what it demonstrates is that as an organization, we're very closely tied in with a number of very large sort of lenders, banks, companies, and they don't just look to us to provide advocacy services, but also to provide guidance on the litigation in general. And because we're recognized as being the industry leader really in these sorts of in the kind of areas where we specialize in attending hearings.
Super, thank you. Those are all the questions in the chat. Again, just giving people a moment if there's anything else they'd like to ask. Oh, another question's just come in. Is work based on availability of the advocate, or is it target based?
So it's based on availability of an advocate. So we do request that all advocates are available at least 2+ days in the diary. But then it is based on availability and obviously location. We do try to distribute the work evenly amongst all advocates. Obviously, the more you're available in the diary, the more work you will get. And we do feel that obviously you benefit from our training, and that obviously the more hearings you do, the more experience you get and the better you become. So obviously the more you're available, the quicker you're going to move through that process. But yes, you know, if you want to do it on a part-time basis, that is acceptable. What we do ask that all advocates can be available at least 2+ days.
Great, thank you. And there's another question about pursuing a career as a solicitor, which I suppose Barbary might be able to take that question as well, perhaps. But I'm a fresh law school graduate from Pakistan, and I was wondering what my next step would be in regards to pursuing a career as a solicitor. I don't know if LPC have got anything to add into that, or I can point them in Barbary's direction otherwise.
I think we'll have to point in Barbary's direction. Right? I mean, it might be a case of yeah, I think it's probably a case of the relevant qualifications.
Yeah.
To become
Yeah, absolutely. So Nafessa, we can follow up with you directly on that in regards to preparing you and giving you information about the solicitor's qualifying exam that you'd need to take in order to qualify as a solicitor in England and Wales.
Just out of interest, did anyone watching, was the hearing different to maybe what they'd anticipated? Just a lot of advocates who start with us, or they're quite shocked at the beginning as to kind of you know, how mortgage hearings take place, maybe how quick they are, and comparatively informal to maybe what they were expecting. So did anyone have any sort of I don't know, did it really surprise anyone, or was it pretty much what people expected?
So we've had it didn't expect it to fly by. So comments on the speed.
Yeah.
Sorry, yeah, so like I said, I guess some hearings do run relatively smoothly. Obviously on that hearing there was judicial intervention. There was questions raised both about paperwork and obviously issues that were raised by the defendant. Again, it all depends on the type of hearing and I guess the issue raised. Some hearings can even be quicker than the one we demonstrated. You know, some judges like to deal with them very, very quickly, very succinctly. As I said, they'll ask for the information and they make a decision very, very sharpish. Other hearings that you may expect to take 10 minutes end up taking, you know, an hour or more, depending on the issues. But I guess that's part of the joy of the job is you don't know what you're going to expect, and no day is the same. Yeah, and I think that's all part of the, I guess, part of the enjoyment of it, really.
Super. Oh, just one more comment. It didn't surprise me. It just made me wonder if one has to be well grounded in an area of law to do so well in that area, especially if the timeline appears to be short.
Well, like I said, we do cover all areas of civil litigation, but the areas that particularly that you would be starting in would be related to mortgage relating, housing matters, consumer credit, bankruptcy. And as I said, as part of our service commencement program, we do give you, as Pete said, 12 to 15 hours worth of videos to watch. You answer the questions, you get the model answers, and also we give a comprehensive guide. I think it's now about 200 plus pages now, which cover all the different types of areas of law. So if you do pick up a bankruptcy matter, that would be the first place to look. We have a whole chapter on bankruptcy, what paperwork you need, kind of standard submissions that might be made by a defendant, covers things like costs and order sorts. So I guess we have set up a program to train people that don't have any previous knowledge on these types of law, but by the time you've gone through the program and you are ready to accept your first briefs, we're confident that you will have the material that you need to be able to proceed.
Fabulous. Well, I think that is the end of the questions as far as I can see. I don't know, Holly, Pete, Estelle, if there was anything else that you wanted to add before we draw it to a close.
No, again, I'd just like to thank everyone obviously for joining today, and to Barbary for hosting the event. As stated, there are a number of ways for you to contact us and to get involved, I guess. The main resource is obviously our website, so please do visit there and have a look. Really, we've put as much information on there as we can. There's quite a lot of information about our application process and what you need to do to apply. And if it is something that interests you, then please do go ahead and apply. And yeah, we look forward to working with you.
Yeah, and good luck to everyone with their studies and their future legal careers. I think it's fantastic, the opportunities that you're providing. It's obviously a really good program. We just hope that everyone does well and achieves their goals.
Wonderful. Thank you so much, LPC Law. And we will be sending the recording and the contact details that Holly has displayed on the screen out to everybody who's attended today. Thank you.
Thank you very much. Thank you, Lucy.
Thank you.